Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on retirement accounts and your estate plan. With retirement accounts, if you've come in and you've created a trust, this is something that we'll always be discussing. A trust is a critical part of your estate plan, and we're always talking about making sure you get your property to pass through that trust. So the question always comes up with different types of assets, and retirement accounts are a critical one. Now, with a retirement account, you're not changing ownership of them. Given the laws that created the opportunity for retirement accounts, they have to be owned by an individual. So we're never talking about changing ownership from yourselves to the trust for that retirement account, but we do have to deal with the beneficiary designations. So retirement accounts are going to pass outside of probate regardless to the beneficiaries that you name. And so the primary question becomes, do I transfer this, do I name the trust as my beneficiary on my retirement accounts, or do I name spouse or kids as the beneficiary on that account? Now, there are also a few things that are a little bit different now than they used to be, given the Secure Act, which went into force in the beginning of 2020. The primary thing that the Secure Act does is that for most beneficiaries, other than the spouse, and other than minors and disabled children, few others, but for most beneficiaries, where they used to have a opportunity to stretch out distributions over their lifetime, now they're limited to a 10-year period. So if we're dealing with a trust that deals with this limitation, it can pass outside the trust or it can pass inside the trust, you still have that 10-year limitation. What are the factors that kind of aid in that decision of, do I pass it through the trust or do I pass it to direct beneficiaries? So in the first place, if you are married, we generally suggest that you have the spouse be named as the primary beneficiary, and that's because different from other beneficiaries, they still have the opportunity to stretch out distribution over their lifetime. They have favorable schedules and they have life expectancy tables that apply, and so it's generally best for them to be named as the primary beneficiary. Now, obviously, you may have different planning needs and particularities, and so that's not straightforward advice, but it's generally what most people will want to do, given all the facts. Now, so then the secondary question is, if it's not going to a surviving spouse, then should it go through the trust or not? So here's the deal. If we're dealing let's say we're dealing with children. This is simpler to deal with it this way. Should I name the trust or should I name the children directly? We're also going to assume that they're all adults and healthy. Therefore, we're only dealing with a 10-year period of withdrawal of that account from the time of your death. Then here's the difference between it going directly to those beneficiaries and passing through the trust. Now, in the first place, again, you still have the 10-year limitation. There's no change whether it's inside the trust or outside the trust. But if it passes through the trust, then there's one party, maybe multiple parties, but there's one party, there's one role of who makes those withdrawal decisions. So there's no minimum distributions over that 10-year period. It's just, it all has to be withdrawn before the end of that period. So it's the trustee, if it's passing through the trust, it's the trustee that makes that withdrawal decision. And the trustee can withdraw, an equal amount every year over the course of those 10 years. It can withdraw it all in the first year. It can stagger it out pretty haphazardly and finally complete it in the 10 years. It can wait the entire 10 years and then pull it all out on the last day before a penalty applies. Any of those things can happen. The thing to remember is the mechanics of that is the trustee is the one that has to communicate with the IRA, the financial institution, making those withdrawal decisions. But in all of our trusts, we create those as conduit trusts, unless we have a standalone IRA trust that allows the trustee to accumulate and hold those distributions or those withdrawals before distributing them out to the beneficiaries at their own discretion. Then we're dealing with the trustee having a duty to make those withdrawals and then pass them directly to the beneficiary. Now, that's not a lot different from if it goes directly, the beneficiaries are your children are the direct beneficiaries of your IRA account. In those cases, each of those beneficiaries for themselves will request withdrawals from the IRA administrator and get those withdrawals themselves. So in the first place, that's the mechanical difference there. If it's going through the trustee is the one making those withdrawal decisions and then having to pass them down directly to the beneficiaries immediately. They can't retain them and hold them in trust, versus each beneficiary, each child, essentially making their own request over that 10-year period, however they want to do it. Now, that's the first part of that. The other part of that is what happens if any of those beneficiaries was not to survive you. So if you're dealing with just the beneficiary designation with the IRA institution, the administrator, then, well, there's some question there. Generally speaking, if you name, okay, I've got spouse first, then it's going to the kids. When it goes to the kids, you know, you've got your 4 kids laid out there as the beneficiaries. What if one of them passes away? Now, I can't speak to all the different beneficiary designations and how they allow those to kind of be written. They may have allowed for that to pass. You know, you name the 4 and one passes away and they have kids. It may already allow for those to be divided up amongst their children. And then, you know, that may cover most people's issues, but I don't know, and you might have to check depending on your particular agreement. It may only leave it to survivors. So if you have 4 children, they all have children of their own. One of them passes away, leaving survivors. It may be that instead of that share going to their children, your grandchildren, it goes to the other siblings. Now, that may or may not be a situation you're comfortable with. If it passes through the trust, you have more control over who it goes to, for one thing. Your trust, in most cases, probably defaults and says, okay, if one of my kids passes away, their share goes to their kids. It may also be that you have some other different contingencies in there. It may be that you know, you do want it to go just to the children. And it may be that you change your mind in 5 years. Well, if you change the trust, then you've changed those contingencies and the distribution is going to pass through the trust anyway, and you don't have to deal with the IRA administrator for those changes. But if you go directly through the IRA, well, then you have to know what's going to happen in these eventualities. If my child passes away first, does it go to their kids? Do I want it to? And 2, if I change my mind about that, I'm going to have to go back to the IRA administrator and fill out their forms and go through that process and change it that way. So as with most things, where the trust can be this kind of bucket where you say, okay, all my distribution provisions are going to be here. And if I make any change to that, if I decide, you know, I want this to distribute this way or instead of that way, I want this to go, this child needs more because of their health problems, so I'm giving them a greater share. Well, that's what's going to happen if it passes through the trust. If it passes outside of it, then you're either going to have to change those beneficiary designations, change your trust, and then change that beneficiary designation as well so they're consistent, or else, you know, you're going to have those things are going to be going in different ways, different amounts, and it won't be consistent. So like I say, it can pass outside the trust, it can pass through the trust. There may be advantages or disadvantages to both. What you need to think about is kind of what your interest is, what you're most concerned about. And in some cases, you may want to have it pass through a separate trust instead, where the trustee is allowed to, a standalone IRA trust, where we create provisions that allow the trustee to be able to bring in those withdrawals and hold them in trust for the asset protection, distribution, discretion, and over time for that beneficiary for a longer period of time instead of only be limited to those 10 years. There are a lot of things to consider. Again, there's financial considerations you should discuss with your financial advisors, tax considerations to discuss with the CPA, and you know, we're always available to give guidance on these and help create the right trust vehicle, or of course, option being yours to have those things pass outside of the trust. We want to make sure those things are aligned so that your estate plan works the way you intend to. If you have any help, need any help, have any questions, as always, give us a call at Stone Law.